Hello. So we'll be looking at the annual returns where the CAC has gotten the authority to strike off names of companies from the registry and also remedies to entities that are affected by the striking off. Number one, what are annual returns? Well, the name is very fitting and proper to it. Annual. So these are returns made by registered entities to the Corporate Affairs Commission, setting forth one, that they are still going concerns or they still exist. Two, and that they are carrying out their business in accordance with the law. For example, a small company will indicate that it does not have more than 50 members. It will indicate that it does not have more than 120 million naira as turnover for the preceding year and does not have over 160 million, over 60 million naira rather, as the net assets of the company in the preceding year, etc., etc. Thirdly, annual returns help the Corporate Affairs Commission to generate revenue for the federal government of Nigeria. Now, where does the CAC get the authority to strike off names of entities that have not filed their returns? This is very simple. Somewhere around section 692 of the Companies and Allied Matters Act indicates that the CAC may take steps to strike off the names of entities that have not filed their returns with the Commission for a continuing period of 10 years. Remember the first reason for filing returns we mentioned. It indicates that that entity is in existence, it's still carrying on business. So if you're not carrying on business and you're no longer doing what you're required to do, the Commission is safe to assume that you no longer exist and should not occupy space on the register of members. So the Commission can then issue out a 90-day notice. The essence of this notice period, in my understanding, is for companies that may be unjustly affected to come forward and say that they are still going concerns and that their name should not be removed from the register of entities or of companies. After the expiration of these 90 days, the Commission can now take steps to strike off the names of entities that have not come forward during this period to rectify their records of the Commission. Now, what is the remedy to companies who are eventually struck off? The law goes ahead to say that where an entity is struck off, the entity itself, that is, the company, the shareholders of the company, or the creditors of the company, may within 10 years after that striking off has happened, apply to the Federal High Court, giving cogent reasons why it is expedient that the name of that company be relisted on the register of companies. When this happens, one may now begin to wonder what is the difference between a striking off done by the CAC or the courts and the winding up of a company. Well, the striking off of a company does not necessarily, in fact, it does not at all indicate that that company has ceased to exist. That is to say, all interests existing in the hands of third parties against the company itself can still be enforced against the company as if such a company still exists. Remember that in a winding up, all creditors are settled or at least compromised with, in that once the winding up is finally settled, that company ceases to exist and can no longer be revived like it happens in the case of the striking off. Now, if you have found yourself in the part where your company is affected, you should now take steps through a registered or accredited agent with the CAC to fulfill the outstanding requirements, reach a compromise with the Commission, that is by paying the outstanding sums, filing the necessary returns, and then having a Commission release you before this period expires. I'm sure for those of us who are operators of registered entities in Nigeria, some may not have heard this. Um, so this is an opportunity for you to know what it is. And then lastly, may I say that do not find yourself operating an entity if you're not going to take steps to live the life of that entity with the commission. It's been Ayede School of Law. Thank you.